My Lords, I didn't stop in a particularly logical place in my submission, so if I can just go back to what I was just saying before Rose and then go on. Looking at paragraph 3.6 on page 527, my submission that I made just before we rose was that 3.6 gives some high-level guidance to the methodology that the valuers can deploy. 3.6a contemplates assessing the historical and projected financial performance of the group. And that, we say, as you know, requires assessment of the actual performance of the group and its projected financial performance based on its proposed actual business during the relevant period. But as I said before we rose, 3.6 does not stop there. It doesn't say that any valuation of the group must stop with that assessment in 3.6a. Subparagraphs B and C mandate the valuers to apply a range of generally accepted methodologies for valuing the group. And so if the valuer, just looking at 3.6b, if the valuer, having regard to other valuation methodologies, comparisons with publicly disclosed sales of other companies and so forth, if the valuer considers that a prospective purchaser or purchasers would attach a premium to the group, for example, over and above any value that might be implied from the assessment of the actual performance based on the projections, to reflect untapped potential, then it's open to them to take that into account in the exercise of their professional judgment. So that's our case. I hope that's clear. Mr. Weeks said yesterday that our way of looking at things is to approach things from the wrong end of the telescope. And we say, with respect, it's WRL that seeks to approach things from the wrong end. What they're seeking to do is to bake into the projections to be provided under paragraph 37b6, projections for a business which, as I said yesterday, doesn't exist and is not planned to exist over the applicable 3-year timeline. And when I say planned to exist, I mean planned in the only relevant sense, which means which is planned in the business plan. That's the only relevant sense in which one can talk about plans in this context, because as we saw yesterday, the business of Viva has to be conducted in accordance with the business plan. Now, Mr. Weeks justifies this baking in of these projections, these US projections, if I can call them that. He seeks to justify that on the basis, he says, that one needs to do that in order to come up with the open market valuation of the business. He says in order to come up with the open market value, you have to provide the experts with the relevant data to come up with the valuation. That's his submission. But that's misconceived. The valuers are valuing the business which has been built. In doing so, one of the approaches that they will very likely adopt is to carry out a discounted cash flow analysis on the projected performance of that business over the next 3 years. And if that business has no plans, in the sense that I've just described, to carry out business in the United States, there is no justification or rationale for including figures in the projections in relation to a US business. What WRO is ultimately seeking to do is to tie the hands of the valuers by forcing them to attach value to a business which does not exist and which is not planned to exist. And not only that, but to force them to attach value on the basis of projections cobbled together by Viva, which may bear no relation to how a prospective purchaser might wish to expand its business, expand into the US, assuming that it has that wish at all.
Yeah.
Nor might it bear any relation to any premium which the expert, in the exercise of their independent judgment, may think a purchaser might be willing to pay to reflect Viva's untapped potential in the US market.
Yeah.
And there was a very revealing exchange yesterday, page 140 of the transcript, when my Lord Justice Lewison asked Mr. Weeks why paragraph 3.8 does not permit WRL to provide some further projections to the valuers reflecting what it says Viva could be doing in 3 years if it was free of Regulation K. And Mr. Weeks answered that paragraph 3.8 is a matter of discretion. In other words, the valuers would not regard themselves as bound to attach weight to those projections if they considered, in the exercise of their professional judgment, that they were, to use my Lord Justice Lewison's expression, all pie in the sky. So as I've said, what WRL is seeking to do is to tie the hands of the valuers, to force them to ascribe value to a non-existent, unplanned business, and there is no legitimate basis for that. Put bluntly, WRL is trying to interfere illegitimately with the experts' approach to their valuation with the aim of driving a higher option price. Pure and simple. Mr. Weeks also echoed yesterday the judge's point below that neither paragraph 3.6 nor paragraph 3.7b6 refers in terms to the business plan, and that submission was again repeated this morning. I'm sure your lordships have the point, but when we say that projections must be based on the business plan, what we mean is that they should reflect the business that the group is actually planning to carry out during the 3-year period referred to in 3.7b6a. Can I come next to the reality principle? And you were taken this morning.
Well, I suppose you could have a scenario, couldn't you, where, notwithstanding what was in the business plan, there was some internal document of Viva's which demonstrated that they were planning to burst onto the market in South America or something. And which was, you know, as it were, a board paper that was sort of properly reasoned. Valuers would be entitled to take that into account under 3.8.
Yes, yes. The 3.8 is very widely worded. It's very widely drafted. Any other factors?
There's nothing in the business plan that says anything at all about anywhere other than Europe. Certainly nothing that says anything about the United States of America.
Yeah. So
it's just, to use my lord's expression, pie in the sky.
Well, there's nothing. You're absolutely right, my lord. There's nothing in the business plan in relation to the United States. Why on earth? Then what is the justification for providing valuers with projections which must be agreed, and we adopt respectfully all the points that were made around the practicalities of trying to agree a whole new set of projections in relation to a business which doesn't exist and which is not planned in the business plan? No. There's no justification for including that in the projections.
As I recall it, the business plan is supposed to be updated every quarter, isn't it?
No, so in Q4 of each year, it's then updated. I think it's clause 10.7 from memory. Should we just have a look back at that?
Of the main contract?
Yeah, the main agreement, yeah. So it's page 490. So you're right, 10.8, the board has to review it every 3 months.
Sorry, okay.
But it actually gets updated, I think, annually in the final quarter. That's 10.7a.
Yeah. 90 business days before the expiry of the subsequent.
Yeah, but there's also 10.9. There's nothing to stop the parties from agreeing to amend it at any time.
Yeah.
Just needs consent. Shareholder consent.
So, I mean, the review presumably doesn't involve people just saying, okay, read that. I mean, review means, it's not a static document, is simply the point.
No.
Yeah.
No. Right. So you've taken to Curzon this morning on the reality. Yeah, and I wanted to, if you don't mind, I wanted to take you actually to the decision in Harbinger itself. You were shown a passage quoted from my Lord Justice Lewison's judgment in that case, but I think it's better just to actually have the case itself, so we get a little bit more out of it. There is unfortunately no headnote, my lord, so I'll do my best to explain. We can pick it up at paragraph 1. On the 22nd of February 2008, Northern Rock was nationalised. Upon nationalisation, all existing shares in Northern Rock passed into the government hands. The issue on the appeal is the base on which compensation for those shares is to be determined. And then you can see that the compulsory transfer of the shares to the Treasury solicitor was effected under a statutory instrument. And you can see section 5.4 of the instrument is quoted in paragraph 2. Determining the amount of any compensation payable by the Treasury by virtue of any provision in an or under this section, it must be assumed A, that all financial assistance provided by the Bank of England or the Treasury to the deposit taker in question, i.e. Northern Rock, has been withdrawn, whether by the making of a demand for repayment or otherwise, and B, that no financial assistance would in future be provided. So what was going on here was the government had nationalised Northern Rock. I'm sure this is familiar to my lord, but for the benefit of the other members of the court. Northern Rock had been nationalised. The question was essentially what compensation was payable to shareholders who'd had their shares taken away, and that required one to value, a valuation exercise. But the valuation exercise obviously had to assume that all the support which the Treasury had provided to Northern Rock had been withdrawn, because otherwise people were getting a windfall at the expense of the public purse. So that was the idea. Financial assistance, we just cast an eye briefly on paragraph 3 where it's defined. And then we can go to paragraph 6. The amount of the compensation was to be assessed by an independent valuer appointed by the Treasury. The appointee was Mr. Caldwell. He determined the value of all shares in Northern Rock, both preference shares and ordinary shares, as nil. In so doing, he applied the valuation assumption in section 5.4 on the basis that it required him to assume that at the transfer time, Northern Rock had repaid, that's important, had repaid all monies that had been lent to it by the Bank of England, and had realised sufficient of its assets to enable that to have been done. So just putting some context around that, what the valuer had essentially assumed was, when the financial assistance was withdrawn, what that required him to assume was that Northern Rock had repaid the government all the money that it had pumped in. That would essentially have required a fire sale by Northern Rock of its assets, which would have meant that it would have ended up being, in that counterfactual world, insolvent, therefore value of shares nil. And then we can go on in the judgment to paragraph 19. The issue in the appeal turns on the meaning of the assumptions in section 5.4a of the Act, that all financial assistance provided by the Bank of England or the Treasury to the deposit taker in question has been withdrawn, whether by the making of a demand for repayment or otherwise. As noted, the tribunal upheld the valuer's interpretation of that assumption, harbouring a say that interpretation is wrong and put forward two alternatives, which your lordships can now read, please. So essentially what they were saying was the assumption should be that although the loans have been, repayment of the loans from the government had been demanded, they hadn't actually been repaid, hence no need for a fire sale, hence Northern Rock would have been solvent rather than insolvent. And then we go to paragraph...
Quite an ambitious argument.
It's the one that was made. And then one has paragraphs 22, I think we saw before. But the key sentence from my submission is the last 5 lines on the page. The most important of these well-established principles is that things are to be taken as they are in reality on the valuation date, except to the extent that the instrument postulating the hypothetical transaction requires a departure from reality. Then at 23, you've seen this extract before, you might just wish to remind yourselves briefly of the various propositions.
Yeah.
And then at 24, if we just pick up the bottom of the page, you'll see it was argued that you see the front at the bottom of the page, but I do not accept, going over the page, I do not accept the reality principle has no part to play in interpretations, which Lord Justice Lewison rejecting the submission of Harbinger. He then refers to the Court of Appeal's decision in St Martin's Property Investments Limited. The rent review clause should be construed with reality in mind unless the words are clearly to the contrary to reflect the reality. And then an extract from Lord Justice Buxton's decision in the same case. And then at 26, in my judgment, the principles I've summarised are those which we should apply in our case. Accordingly, the value of the shares should be assessed by reference to the facts as they stood at the transfer time, except to the extent that either the Act or the scheme requires a departure from reality. A departure from reality must either be expressly required or must be an inevitable consequence of what has been expressly required. Where a departure from reality is required, that departure should be kept to a minimum. And then, if I can take you on, please, just to 38, just a few extracts. So if you could look at where 38 starts, then go over the page, please. About 8 to 10 lines up from the bottom of the paragraph, if you can find the words "the future at all" in the left margin, about 8 or 9 lines up. So what the valuer has to do is to assess a potential purchaser's perceptions of all future possibilities on the valuation date. In assessing future possibilities, the purchaser will have regard to current facts. And then, if I can take you, please.
Were you, sorry,
Yes.
I lost that paragraph.
Sorry,
38.
38.
About sort of 10 lines up from the end of the paragraph.
Your Lordship can see the words "the future at all" in the left margin, about 10 lines up from the end of 38.
Right, thank
It's
you.
those next 4 lines.
Yep.
And then I think we can go through just to 46 and 47. So 46, we can pick it up about 8 lines from the end of the paragraph over the page. The basic principle is that the valuer takes reality as it was on the valuation date, subject to any departures required by the hypothesis under which he values. But he makes no assumptions about the future. His job is to determine what price would be paid for the asset in question on the valuation date itself. Whatever might happen after the valuation date has not happened either in the real world or in the hypothetical world. The purchaser will no doubt consider all possibilities, but he would be foolish in the extreme if he were confidently to predict the future. And then can I just invite you to read paragraph 47. And so, my lords, just having looked at those passages,
This was a dissenting judgment.
yes, my lord, but I think
Not on
not on
reality,
description of the
but-
principles, but on the application as I understand it. Yeah.
That's my understanding too.
Yes. Yes. So, my lord, we say that the key points to take from my Lord Lord Justice Lewison's judgment in that case are these. First, the valuer must proceed on the basis of reality, except insofar as the instrument postulating the hypothetical transaction requires a departure from reality. That's para 22. Second, this operates as a presumption which is relevant to the interpretation of the hypothesis. That's paras 23.1 and 24 to 25. This means that a departure from reality must either be expressly required or an inevitable consequence of what was expressly required and should be kept to a minimum. That's paras 23.6, 23.3 to 5, 26 and 47. And fourth, and finally, the valuer should not make assumptions about the future. All that a purchaser and thus a valuer can do is to assess the effect on the current value of future possibilities, and that's paras 23.6, 38 and 46. And we say that WRL's case is in conflict with these principles. First, WIL's case requires the valuer to make an assumption for which there is no express basis in the shareholders' agreement, i.e. that the purchaser will not be subject to Regulation K, or at least that a purchaser will take no account of the fact that potential purchasers, or at least that a valuer will take no account of the fact that potential purchasers, such as large US banks, may well be subject to Regulation K. Second, it requires the valuers to proceed on the basis of projections that assume a particular US business contemplated by Viva's management that is not the inevitable consequence of the assumed over market value. And third, it requires the valuer to make assumptions about the future rather than to place a current value on a range of possibilities as at the valuation date. So that's what I would propose to say, subject to any questions you may have on ground 1 and also ground 2, which is contingent on ground 1. Ground 3, this comes back to the appointment of the TVE. From the outset, and the construction of clause 3.10 was on page 530. I invite you all to just turn that up.
Which ones to look at? 3.10.
3.10, yeah. It's the construction of 3.10 is what I'm on now, and the point at which the TVE falls to be appointed. Now, it's common ground between the parties, and I think accepted by the court, that the language of this clause is unclear. We can all agree on that. Nevertheless, the court must grapple with it.
Yeah.
It's not a clause which is capable of an easy, literal interpretation. So it requires a little bit of grappling. Now, our case, just try this slightly different way to see if your lordships look at clause 3.10b, the function of subparagraphs 1 and 2 is to provide the definition of the defined term, the third valuation expert. As you see the words, in either case, the third valuation expert, in the very last paragraph. So that is the function of 1 and 2. So if you then come back and read the clause, and if we could just ignore A at the moment, and just take the chapeau and read it straight into B, if the call option fair market value of the shares, as determined by one valuation expert, is more than 15% apart from the value determined by the other valuation expert, with the lower of the two valuations provided by the valuation being the base of these purposes, then the parties shall appoint the person identified in 1 and 2, brackets, defined term, the third valuation expert, and the third valuation expert shall be requested to determine the call option fair market value of the shares within 15 days of its appointment, and follow the process as set out in this paragraph 3. Now, so far, the word appoint and appointment has the same meaning. The clause that I just read out, so the word then the party shall appoint, that word appoint there, and the word appointment in the penultimate line of the last paragraph have the same meaning. They mean appoint to the task. The only place where appoint, on our case, bears a different meaning is in the final line of paragraph B2, which is dealing with the fallback mechanism whereby the TVE can be appointed, i.e. selected, by the ICC if the parties don't agree. And our submission is that is a perfectly tenable, perfectly reasonable reading of the clause. and and that's how we invite the court to construe it. Now, in submissions earlier this morning, it was suggested by the court at one stage that one can simply excise the word effective date, which of course is a real problem. The presence of that phrase is a real problem on WRL's interpretation. And with respect, it's not possible simply to excise that language, the words of the effective date. 10 business days after the date of delivery of the valuation reports would take you to about, so if we look at the 2023 timetable, the 10 business days would take you from New Year's Eve through to the 16th of January by our calculations. So on the 16th of January, it has become apparent that, in this example, it's become apparent that the parties can't agree on the identity of the TVE, and therefore the ICC can now be approached to appoint. The window closes on the 29th of January. So there are 13 days left for the appointment, the ICC to actually make the appointment, and for the report to be produced. So if the way in which the court was understanding this was that there would still be 15 days for the experts to produce their reports, the answer is there would not be. And it's inconceivable that the ICC would appoint within a day. It wouldn't take a period. So our submission is that as a matter of commercial common sense, the parties cannot have intended.
Well, why is it inconceivable? I mean, if at the start of the 10-day period for agreement, and of course you probably have to wait 10 days to at least see that there might be disagreement, but if at the start of the 10 business days one of the parties approaches the ICC and alerts it to the fact that they are in a 10 business day period seeking to agree and might conclude pretty quickly that they couldn't, or might only conclude that they couldn't at the end of the 10-day period, why can't the ICC be, as we're warmed up, to do an appointment pretty much immediately they're told, time we haven't agreed, bang?
Well, the first point is that even if they could, the timetable doesn't work on the example that I've given.
But it doesn't.
Because it's 10 business days, not 10 days.
I mean, it could still work because people could conclude earlier, for example. It's still possible. It's just if you assume that everything takes as long as it's allowed to take. But why do you say that the ICC just couldn't even make the appointment within the period?
Well, I would say that it's unrealistic. If the court is positing that a party writes to the ICC at the beginning of the 10 business days, I appreciate I can't rely on post-contractual events to construe the contract, but the reality is, and I'll show you this very briefly in a moment, it took the ICC months to make an appointment.
Because there was a dispute about manifest error that may or may not have had any force to it, but you can understand how they might have been a bit reluctant to do anything.
There's a process to be gone through. The question about teeing them up. What's happened on the facts? I'll show you in a moment.
I mean, the difficulty that I have with all your argument on this ground is, and I appreciate the point about effective date. I think we all do. That's obviously, it just doesn't work on Mr. Weeks's way of approaching this. But the difficulty you've got is that there's absolutely nothing in the contract to suggest that the third valuation expert is somebody who's appointed before there's, as it were, a dispute, in the sense that there's a more than 15% difference between the two experts. This whole thing is predicated on there's a more than 15% difference. And it's only when there is a more than 15% difference you get to having to appoint a third valuation expert. If what you were really trying to do is say, right at the outset, because this is all going to be, this needs to be done PDQ, so we need to tee up all sorts of things. If what you were really intending to do is what you say they're intending to do, we can very easy to insert a clause saying, as at the effective date, at the outset, the parties will, out of an abundance of caution, appoint a third valuation expert. If they can't, they'll ask the ICC to do it. And the third valuation expert will sit on the wings until he's required to actually do something.
Well, I accept that, but of course, with construction disputes, each side can always say to the other, well, if it had meant, if it had meant what they say,
And one of the difficulties that, speaking for myself, that I've got is that both sides' constructions have got their problems.
Yeah.
Usually, in cases like this, you after you've heard counsel's argument, you come down on one side or the other in terms of realising that one side's construction of the contract is better than the other one. Here, we're in a situation where you've both got problems.
Well, I accept your lordship's point that if you read 310 as though it's a paragraph, as though they flow from each other chronologically, then I see the force of the point that you're putting to me.
But underpinning the whole of your argument is that the parties must have intended the third valuation expert to furnish their valuation before the time came, before the latest time came,
Yes.
the service of the notice.
Yes.
It is possible that that is not what the parties envisaged. That at the time when the last day for service of the notice arrived, the server knew what the parties' individual experts were saying, and therefore knew the parameters of any dispute about valuation, and was in a position to make a judgment about whether or not to serve the option notice.
Well, my lord, the flaw in that is that the option, the person considering whether to grant their option won't know the parameters of the dispute. Because of course, the valuation, which is carried out by the third valuation expert, you take that value and you average it with the one that's nearest. So if the TV comes out above everybody else, above the other two, the option price is going to be increased.
That very, very occasionally happens. It very occasionally happens that you have two experts instructed by each party who give their view, and a third valuer selected actually goes outside that parameter. I mean, I've seen it happen, or I've seen it referred to once. I've never seen it happen.
Well,
I mean, it's conceptually possible, but my lord's point, I think, is based upon a bit more reality, if I may say, which is that third value is likely to be within the two parameters, rather than outside.
well, hold on. You're, with respect, assuming that the third valuation expert gets sent the first two valuations and is basically asked, which one do you agree with? That's not the exercise. They're asked to do it off their own bat. So this is not like some sort of arbitration process or
Hang on.
expert determination.
No, but wait a minute. The expert will know that the expert, if appointed, will know that he's only been appointed because the other two are more than 15% apart.
Yeah.
I mean, which evaluator in those circumstances would not ask for sight of the other two valuations?
But there's nothing in the contract which says they should necessarily have it.
No, nor preventing the third valuer from asking.
I agree they can ask, but I'm just, what I'm really reluctant to accept is that what's envisaged by this clause is that the third valuation expert comes along and essentially is given two reports and said, well, what do you think as between those two? That's not, as I read the clause at least, that's not
He
what's
has to form an
envisaged.
independent view, but
Yeah.
your idea that we should really dictate the determination of this clause but on an assumption that the third valuer is going to come in outside the range of the other two is certainly not where I would start as an assumption.
Well, you might think it's unlikely. You might think, I'm not sure I accept the premise, but let's assume that that's unlikely but could happen. We're talking about valuations for this business. The floor value, is I think 5 billion. It's not a rounding error if the expert goes up a few percent. So anyway, you have my submission, and I just want to answer my Lord the Chancellor's point. I accept that if if you read the clause as though each of these paragraphs flows through chronologically, then I entirely understand the point that you're putting to me, because then it follows that you only get into B1 after A has already happened.
Yeah.
The construction that I'm urging you, or inviting the court to accept, is one where you read the function of B1 and 2 as defining what the third valuation expert is. As I said in opening, you almost put round brackets around 1 and 2 and treat it as though it's an equation. And that's a sort of self-contained aspect. And if you see it in that way, it doesn't flow chronologically, because you have A has to happen before the beginning of B, because you have to be then more than 15% apart before you get into B. But then the party shall appoint whoever is identified under 1 and 2, or who has been identified under 1 and 2, and then the clause reads on, and it makes perfect sense. So that is how we say it should be read, and that is our answer to my lord's point.
Okay.
I want to just take literally 2 minutes just to show you something in some documents from the supplementary bundle, because it was put to my dear friend by my Lord Justice Snowden that actually the parties could warm up the ICC in advance, get them ready, and that was a practical solution. And my dear friend made some very reassuring and compliant noises. So I just want to show you in 2 minutes what we're actually dealing with here. Can we take the supplementary bundle, please?
This is your post contractual evidence with a view to assist us with interpretation, is it?
Well, what I'm going to is, if the court is contemplating writing a judgment saying, don't know what the fuss is all about here, because it was readily accepted by WRL that the parties could simply go to the ICC, you need to have seen this. It won't take more than a couple of minutes.
Right.
So tab 2, JP Morgan to Mr. Kronis, we realised 29th of November, so before the first option period has opened. You'll see paragraphs 4 and 5. Well, they start by saying in paragraph 2 that the first measurement date is fast approaching. They then talk about their own valuation expert, and then at 4 and 5, they go on to say, essentially, JPM is impartial to any of the firms listed in 3.2, the TVEs. Please get back to us by the 6th of December telling us who you want to appoint. Back comes a response next on the 6th of December. They wait till the last minute, tab 3. Basically, this is all premature. No, please confirm, paragraph 5, that you will not proceed to request the ICC appoints an expert. If you do, please send this email. Tab 10, I'll just pick up along the way. It's not actually on this point, but it goes to another submission that was made earlier. Tab 10 is Quinn's letter 3 January. If you go to page 65, paras 7 and 8, contrary to what you were told this morning, the manifest error points that were alleged were not based solely on the point about whether the projections had been incorrect. They said without prejudice to that, and they made a whole series of freestanding points which have nothing to do with that. So their view was, without seeing the reports, they could say that there were manifest errors which were not tied into the projections which had been basis the projections. Moving on and back to the topic that I'm on, tab 13, Quinn's 17th of January, you go to page 76, this is Quinn's 17th of January to the ICC, should make that clear. Paras 10, condition precedent unfulfilled. Para 12, same point, condition precedent not fulfilled. And then 15, no appointment should be made. Proper course is the ICT is to abstain from taking any steps in the appointment process. So much for being warmed up. Abstain from any steps. Next one, I'm coming towards the end. Next one, tab 15, 29th of January. The window is closing on this date.
So which tab?
Tab 15.
15, yep.
29th of January, Quinn's back to the ICC again. This is the last day of the option exercise period. Paragraph 5, position remains the same. Don't take any steps at all. Then tab 18, please. 15th of February, so option period, unless it's extended by implication, has now ended. You'll see the ICC say under next steps, the centre will start identifying candidates for the appointment as an expert in this matter. And then tab 19, Quinn's come back, another long letter, paragraph 2, there have been some further developments, and then paragraph 8, they threaten the ICC with an injunction if they continue along the path that they have indicated that they are taking. So, if it's suggested that the court was thinking that there's any basis to think the parties, there's a sensible way of sorting this out, based on what was said, submitted before lunch, with respect, you need to...
Don't you have to start, when you're interpreting a contract such as this one, to assume that the parties are going to act in good faith and reasonably, albeit that they might reasonably disagree?
Well, yes, but when we're talking about the appointment of the ICC, what the court obviously has to assume is that the parties have not been able to agree on an expert, so it's contentious.
But is there any reason why in advance the parties, if acting reasonably and in good faith, could not have warned the ICC up, or be that there's any? Why do you assume that won't happen?
Well,
I mean,
it's hard not to be infected by what's been going on, of course.
Well, you say, I mean, leaving to one side whether it's admissible in evidence or not, you say that what happened subsequently is that Quinn Emanuel and their client said the ICC has no jurisdiction because there's not yet effectively the 15% dispute hasn't arisen yet. Therefore, they resisted any attempt to warm up the ICC.
Yeah.
And so your point is it's unreal to suppose that you would get sufficient degree of cooperation to make warming up the ICC a realistic prospect.
Well, certainly that can't be assumed when we're construing the contract that that's what would happen. Yeah.
Mm-hmm.
I mean, essentially, this whole litigation, from my client's perspective, is about trying to protect the option process.
Yeah.
There are a number of ways in which this process can be deliberately crashed if you're determined.
Yeah,
and what we're trying to do is to stop that happening.
Yeah.
Ground 4 is the condition precedent to the appointment of a third evaluation expert that there be no manifest error. The scenario in which the court needs to focus on is one where there is a dispute as to whether there is or is not a manifest error. Of course, I take on board all of the points that have been made about how narrow a concept manifest error is, but I've just shown you a letter in which WRL, in this very case, were alleging manifest errors in relation to a report that they hadn't seen, which had nothing to do with, or those points that I took you to had nothing to do with the basis of the projections. So, the scenario is one party is contending that there's a manifest error in one of the valuation reports and that there's a dispute about whether that is the case or not.
Yeah.
The judge below said that in that scenario, the valuation process should proceed. And everybody, there's no dissent from that proposition on the other side. So, alleged manifest error does not stop the valuation process proceeding, does not stop the appointment of the TVE. Common ground so far.
Right.
The dispute is what happens if the valuation process runs its course, the third valuation expert spits out an option price, party A or party B exercises the option, but the other party, determined not to sell, then litigates the question of whether there was a manifest error, and they're successful on that. So they succeed in showing that one of the reports had a manifest error in it. The issue for your lordships is, in that scenario, does it follow that the appointment of the TVE was invalid? And we say no. And the example that I gave yesterday was one where you get to the end of the process, but in fact, the manifest error, as found by the court, actually would have had no impact on what happened subsequently. Because, for example, the error was in Party A's report, but the averaging process that the TVE that was undertaken with the TVE's report was between Party B's report and the TVE's report. So Party A's report, as things have turned out, was irrelevant to the ultimate figure. Now, what's the basis in that scenario?
What if it's the other way around?
Well, I explained that yesterday, but I want to just stick with this for about. I will deal with that, my lord. But the question I would respectfully ask rhetorically is, what is the basis for invalidating the appointment of the TVE in the scenario which I have postulated? There isn't one. What it would enable the party to do is to essentially cancel the exercise of the option by the party who sought to exercise it on the basis of a manifest error in a report that was irrelevant, as things turned out, to the calculation of the option price. And that makes no sense. Now, coming to my lord's question, if it's the other way round, well, there may be some problems then to sort out as to what happens, because the person who's exercised their option would have exercised it by reference to a price, which may turn out to have been incorrect. And then there will be a dispute between the parties as to whether that is a valid exercise of the option or not, or whether the party's actually bound by their notice, because it's conceivable that actually the price that they've exercised at would have been lower. So there may be a whole host of disputes at that point about what then happens, but that's inevitable. But none of that provides any logical, sensible basis for finding that the appointment of the TVE was itself invalid. That's the point on ground 4.
And that's the same in the case of fraud, is it?
Just trying to conjure up in my mind what the facts might be. There's an allegation of fraud in the report, so the expert who has deliberately inflated
Taking the
or
backhander from the client.
Taking the backhander.
right and deliberately inflated or reduced their report. Yes, if an example that I gave, if that report is actually irrelevant to the option price that's paid.
What about if it isn't though?
If it isn't,
Why can't you say that the report is that expert is completely vitiated? So his assessment of what the option price is completely vitiated by the fraud. So the process has to start again. I don't know.
Or do you average with the surviving report, surviving certificate?
well, I mean, I'm not really focused on what fraud would look like. I mean, it might
The
depend
trouble
on.
is because it says fraud or manifest error, so you need to, I think your argument needs to be able to cater for both.
But
I have difficulty with the fraud aspect.
But you'd have to work through, I mean, there are lots of permutations here. If the person who's exercised the option is the fraudulent party who's paid the backhander, you can well see that the court would be reluctant to allow that option exercise to stand, at least if it was at a price which was lower than it should have been. Of course you can see that.
Yeah.
But what if it's the other parties who've exercised the option? And they weren't the party to the fraud, and they want to buy the shares. The court might say, well, actually, what we're going to do here is we're going to work out what the actual price should have been. You fraudster can't rely on your own wrong, and we'll let this person exercise the option at what should have been the correct price. I don't know. There are a lot of complications there, but none of this justifies just putting a line through the appointment of the third valuation expert. Their appointment just doesn't. You'd have to work through the commercial consequences in terms of prices and what was vitiated and what wasn't. But why on earth would you say the appointment itself is vitiated? What happens if
whether it's a fraud or a manifest error, but at the end of the, having, as it were, unravelled the point, the court reaches the conclusion that if it had not been for the dishonesty or the manifest error, the figure that would have been selected would have been one that was within 15% of the other figure. So you wouldn't have needed a third valuation expert at all.
Well, in that instance, you would say that in that
So you go
situation,
back to-
you don't have regard to the third valuation expert's
Go back
report.
to 3.10 B1.
Yeah, you wouldn't have regard to the third valuation expert's report. Well, that's for finally ground 6, the implied term. I don't have very much to say on this. We accept that the usual rules apply. The term has to be necessary and so forth. We don't dissent from any of that. My Lord, Lord Justice Lewison put to my own friend that clause 3.10 is the answer, or could be the answer, because if WRL don't agree to the appointment of a third valuation expert, then we just go to the ICC. But our implied term assumes that WRL has adhered with the appointment of the TVE so as to either prevent or delay their appointment. There's no answer to say to that, well, the clause 3.10 provides the remedy, because the premise of the implied term are in breach of 3.10 and have precluded a continuous either consensually between the parties or by the ICC.
What obligation do they have under 310?
They have,
This is a standard clause which says if you don't agree within 10 days,
Let's go to the
parties
ICC.
shall appoint any one of the firm of accountants as they may agree. So there's an agreement to agree. That's not an enforceable legal obligation. And if you don't agree,
yes.
one of them can go to the ICC.
Yeah. And what if the party then seeks and obtains an injunction from the ICC precluding an appointment, and by the time the return date comes, or it provides it, we're only dealing with a week or two here.
I had a case involving exactly that in front of Mr. Justice Hoffman, and he said, well, in that case it was the president of the RICS who was going to appoint, and the president said, my policy is to appoint. Mr. Justice Hoffman said, quite right. The president's not a pawn in the skirmishing between the parties.
Well, you may, no doubt, you may win the substantive hearing, but you may not get it on in 24 hours flat. As I say, the premise is, and you've seen the correspondence, the premise is that they interfere in a way which successfully delays or prevents the appointment. The question is, what then happens? We say in that situation, assuming there's been a breach with that constitutive effect, the implied term is that the period should be extended, because otherwise my clients can be robbed of their option rights, and WR would thereby benefit from their own wrong. Well, that's all I was going to say in reply, so it's a bit longer than I thought.
Yep.
Good afternoon. My Lord, to turn the famous saying on its head, I have had enough time to reflect upon the submissions I'm about to make so as to make them shorter. I think under the timetable I originally had an hour and 50 minutes.
Right.
Subject to my Lord's better view and helpful interventions, I don't think I shall take that long.
Right.
For the argument, for better or worse, right or wrong, insignificant or not, doesn't bear greatly development orally. It is either one way or the other.
This is the one-shot, multi-shot.
No, this is declaration.
Oh, you're on declarations.
Yes,
are you?
I'm declaration.
Who's going to deal with one-shot, multi-shot?
Mr. Weeks is.
Oh, is he? Right,
Yes,
okay.
he is. He.
So that's quite a tricky one. Yeah.
Yes, that
Right, declarations.
generously passed to my left, as you
Yeah.
can see. Your Lordships have observed yesterday there was a communication black hole on this side of the court. I hope I'm not in it.
No, I can hear you. I
Good.
think we can all hear you. Right.
Thank you very much. My Lords, the approach I'm going to take to these submissions things, your better view, is to be sparing in the references to the documents, because this is not an argument that really derives its life force from the bundle that's about before you. I will invite you to look at 6 or so authorities, although I know you will be familiar with all of them, but just to recalibrate the argument. As I go along, I have for every point a cross-reference to a skeleton argument or something if it would be helpful, but it seems to me to be wearisome to the court when the written arguments fall within a very small compass in each side's respective skeletons, for me to pepper my submissions with references, but I'll gladly do so if in fact I'm wrong and it would be helpful to you. So, my lords, just to calibrate the declaration argument, can I invite you please to turn in the core bundle to tab 5, page 179. And just to remind ourselves of the contours of this dispute that I here address. And the learned judge made an order, a declaration, in paragraph 5 on page 179, that Viva is a subsidiary of JPM for the purposes of Regulation K, and we submit that she should not have so done with respect. Beguilingly simple as the declaration is, it is, we submit, replete with problems. And I'll just give you, if I may, the headlines, and then by reference to the sequence in the skeleton arguments of both sides, develop the 4 points, and then the 5th conclusion, and then I'm done. So in headline form, we submit the following. First, whether Viva is a subsidiary of JPM or not is a matter of US law. Viva is only a subsidiary of JPM for the purposes of Regulation K when the Federal Reserve, or Fed as they came to be called for short constantly throughout the trial, say so.
Is that the second point?
Well, it's part of the first. I will number them as I move on.
So it's US law and something to do with who has to determine it.
Yes. And joined with that is still the first point. The Fed would have no interest in the view of the courts of England on this point. That was the evidence of trial. Secondly, that state of affairs I've just identified is because the subject matter of the declaration is a regulatory evaluation, best, and we say only, properly undertaken by the specialist foreign regulator, the Fed. Thirdly, what the learned judge did with respect was to grant JP Morgan declaratory relief in an action as between JP Morgan and WRL on a matter which lies within the exclusive jurisdiction and discretion of that specialist regulator. Fourthly, the declaration served no purpose, had no utility, as the ruling did not and could not determine the issue that was said to underlie it, nor did it bind Viva or determine its status authoritatively. Fifthly, what the declaration did achieve was to set up a potential conflict by declaring that, as between the two shareholders, Viva was a subsidiary, consequentially to enforce on WRL an inter partes obligation to procure Viva's compliance with regulatory obligations, including Regulation K, but through a fiction. Because whilst that was happening, as a matter of US law, Viva was not and is not, my lords, a subsidiary unless and until the Fed says otherwise. And as things stand, it is not, and therefore the declaration is premised upon a falsehood. And sixthly, all this in the context where the judge's ruling on what she rightly labelled the principal dispute between the parties, i.e. the basis for the valuation of the fair market value, pursuant to Schedule 1 of the SHA, of which my lords have pored so patiently these last 2 days, made the declaration that we complain about here irrelevant. Where Viva, as the subject matter of the declaration, the company whose regulatory status was being declared, was not in the room. And the appropriate route to resolving this issue was through the Fed, tailor-made, and if it needs be, most unlikely on the evidence of trial, but if it needs be, through the US courts, may have been asked already. For JP Morgan wouldn't tell the court below and doesn't tell us now whether the regulator has in fact already determined the issue in the US. It follows that in our submission, the learned judge regretfully fell into fundamental error in granting declaratory relief. And we say that in all our submissions with the utmost possible respect. But the error is manifest, if I can borrow that word. The issue that arises on this ground of appeal can be determined, of course, on its own terms. And we don't invite the court to go further than is necessary to be properly dispositive of this appeal, of course.
Can I just ask you this, Mr. Lewison?
Yes, of course.
As I understand it, you don't challenge any of the findings which the judge made.
Correct.
You only challenge the fact that she made the declaration in the terms which we see in.
Yes.
What was she to do, having made the findings that she did?
Well, we say there are two discrete stages. Stage 1, find the facts. Stage 2, to decide what to do with those facts as found. It doesn't need the likes of me to tell a court of this standing that there are daily thousands and thousands of findings of fact that do not lead to declaratory relief. Of course, that's obvious. What she should have done was to ask herself and answer correctly at the second stage this question: on the facts as found, is it appropriate, by reference to Rolls-Royce and Rourke and Mellon and the other authorities, to grant declaratory relief, yes or no? And we submit she should have answered that question no. So we would have ended up with a series of findings of fact, but a recognition that the declaratory stage was not satisfied by reason of the points that we make in criticism of the judgment.
But a series of findings of fact binding on both JPM and WRL,
Yes,
creating issue estoppels, if nothing else,
potentially, yes.
which could then be used in carrying out the valuation exercise.
They could, depending upon the findings on the other aspects, yes. But qualitatively, quite different to the declaratory relief that is granted for the world to see, that either judge declare as a matter of law, English law, of course, that there is a subsidiary status on Viva, as opposed to findings of fact about that matter, which will be less prominent.
On the material before the court, so you say on the material before the court, she could have reached a conclusion on the facts
Yes,
that Viva was a subsidiary of JPM,
yes, she could.
but left the American law issue undecided.
Exactly so. Exactly so.
And the form of Declaration 5 is not simply tied to the fact finding. It declares that Viva is a subsidiary for the
It
purposes
does.
of Regulation K.
It does, and as I will do it now in response to my Lord's helpful observation. I was going to do it later. It must be borne in mind that the declaration as to the status under Regulation K is not just fact. It is effectively, and if I may be so impertinent, to interpolate some words into it, I, the judge, have found, as a matter of fact, X, Y, and Z, and I then take X, Y, and Z and apply to them the United States law as I have it in front of me from the expert witnesses, and arrive at a conclusion on the American law consequences of the findings of fact that I have made, that the declaration should be expressed in these terms. So it is both fact and law combined, fact and foreign law combined.
Well, that's what she did,
Yes.
is clear from the judgment.
It is indeed, it is. And so, my lords, as I was saying, this can either be resolved on its own terms, narrow issue, and as I recognised before, so I repeat in case I muddled it when I responded to the question, I well recognise that the desire to go further than is necessary to dispose of a given appeal is to be resisted very often, but there is in the permission to, the granting of permission to appeal from Lord Justice Popplewell, an invitation, in the words in which he qualified his granting of permission, as you know, for the court to consider the wider picture. We would frame the wider question, if it helps, which it may not, in these terms. When, if ever, should the English court grant declarations about how foreign regulators would apply their regulations? Lord Justice Popplewell observed that not only were the grounds arguable, but that this ground, using, if I may, his words, raises a point of general importance to the court's approach in relation to decisions within the scope of a foreign regulator as to the status of a non-party.
I must admit, I don't quite follow that. This, on any view, this declaration doesn't bind the Fed,
Correct.
or indeed Viva.
Well, it's actually,
And why should it?
It's our case is irrelevant from the Fed's perspective, what the English courts decided. So it doesn't, so it might,
And indeed, probably for the most part, for Viva's.
yes. But even so, I think what, if I can have a go, I think what Lord Justice Popplewell was seeking to convey in the observations around the grant of permission to appeal was that this is a point which is, if this is what he was conveying, he's right, if I may say so, there is no authority directly on at all. Secondly, that this court might consider what is the right approach in relation to decisions within the scope of a foreign regulator like the Fed, as to the status of a non-party to proceedings before it. So it engages three different aspects of declaratory relief law, i.e. Viva in this case. And we submit that the appeal on this issue should be allowed for four independent reasons, which we present, I hope with appropriate economy but completeness, which track our skeleton argument. I'm taking them in the same order, my lords, with your leave, for coherence and for ease of following, given the fact my lords have been kind enough to pre-read in this sequence. But I do not pretend that each point carries equal weight. And it may well become evident as I develop our submissions where we think that the main weight lies. Four independent reasons. First, that the declaration should not have been granted because it served no useful purpose. That is our primary argument, which, if correct, would be dispositive of the appeal in our favour in and of itself. Secondly, the declaration should not have been granted because Viva was absent from the proceedings. Thirdly, the declaration should not have been granted because it was inappropriate in light of the subject matter of the declaration, which aligns with our first argument, and I'm not shy about saying it may well be the most important point in our arguments. And fourthly, the declaration should not have been granted because the Fed may have already determined the issue, which was the subject matter of the declaration. And I qualify that ground of appeal or complaint by emphasising this: we are not unrealistic in these submissions, and we do recognise the difficulty that the court was placed in, this point arising during the course of the dying embers of learned friend's submissions closing his case, and then all that came out of it thereafter. It was not easy for the learned judge to manage without causing delay and disruption. But I'll come back to what we say should have been done when I deal with that ground. So may I take the 4 points in that order, please? First, no useful purpose. We say, and for the avoidance of any doubt, said from the outset of these proceedings, that the declaration that we're here examining should not have been part of the trial, let alone granted, because it served no useful purpose. It was JP Morgan who wanted for this to be part of the expedited trial, and it was they that succeeded in that argument. If you need sources for that, I have them, but I shall not weary you with them unless I think asked to do so. As I say, this is in and of itself determinative of the appeal if we're right. In their skeleton argument, learned friends raise broadly 3 objections. First, they say that the declaration was of use, as to use learned friends' words in paragraph 72.1 of their skeleton, formally and unequivocally settling this disputed question as between Viva's shareholders. We don't think that it does anything of the sort, formally or unequivocally. It doesn't settle anything. Secondly, they say it was relevant to the valuation exercise, which is, with respect, and maybe the poverty of my own reasoning here, something we find very difficult to follow. And thirdly, they say, and this is a better point, if I may say so, if the valuation, which is subject to appeal, as we know it is, and if that appeal is allowed, this point may well fade or have to be adjusted in the way in which it plays. As regards the applicable legal principles, my lords, I hesitate to remind you of what you know so well, but I wonder whether it would be useful just to calibrate the court's concentration on this point, but so many other things in play, to just remind ourselves of the 3 sources in the bundles which the parties draw upon as containing the principles, starting with Rolls-Royce and Unite. It's the Authorities Bundle, tab 8, page 153. And may I say, this is applied by the learned judge below, correctly recited by her in paragraph 27 of her judgment. So it's Authorities 8, 153. And I know these points are very well known to you. Could I just invite you, just to remind yourselves, please, of the 7 principles captured by Lord Justice Aikins in his judgment in paragraph 120.
Yeah.
Thank you. I'll take that as done. Can I perhaps also invite you to note how the matter was put 8 years before in the less studied on this issue judgment of Mr. Justice Neuberger in FSA and Rourke, and come back in the Authorities Bundle to tab 6 and to page 88. Where essentially the principle is captured in half a dozen lines. If we can come on page 88 to the second line on the page, his lordship says, "It seems to me that when considering whether to grant a declaration or not, the court should take into account justice to the claimant, justice to the defendant, and I would respectfully interpolate here, and justice to a third party. Whether the declaration would serve a useful purpose, and whether there are any other special reasons why or why not the court should grant the declaration."
Mm-hmm.
And thirdly, that was then much adopted and built upon by Mr. Justice Marcus Smith, the Bank of New York, Mellon and Esser, which I'm not going to trouble you to turn to. Time is not really permitted, it's not necessary. But for your reference, it's the Authorities Bundle tab 15, page 404, paragraph 21 of His Lordship's judgment. We make 5 points clear, if I may, at this stage. First, we make no complaint about the judge's summary of the law. Second, we bear in mind and remind ourselves on an iterative basis that the power to grant a declaration is discretionary. Thirdly, it is trite to say that discretion must be exercised according to principle, of course. For present purposes, and this is the fourth point, fourthly, for present purposes, these principles come in 3 of the 7 principles from Lord Justice Aiken's judgment in Rolls-Royce you kindly just looked at. And to save reopening the bundle, it's in the judgment, if you have it to hand, at page 189, paragraph 27 of the judgment. And it is principle 2. There must be a real and present dispute between the parties before the court as to the existence or extent of a legal right between them. Principle 6. The court must be satisfied that all sides of the argument will be fully and properly put. It must therefore ensure that all those affected are either before it or will have their arguments put before the court. Principle 7. In all cases, the court must ask, is this the most effective way of resolving the issues raised? And fifthly, all this is under the overarching banner of utility, whether from Mr. Justice Neuberger in Rourke or from Mr. Justice Marcus Smoot in Mellon. It's the same thing. Is there a useful purpose in the declaration? This court does not need from me and will not receive it, any gloss on those principles. What I do say is that there is obvious good sense in declining, as a general rule, to grant declarations where they are not relevant to any live legal dispute, especially when there is a tailor-made, accessible route designed for the very purpose of determining exactly and authoritatively the issue in play for the benefit of the parties affected by its decision. And that was laid out in this case in the evidence before the learned judge in the shape of the processes that are part of the Fed's operation manual for resolving Regulation K and other such issues. It is not as if one is faced with one of those cases where the only alternative, if there even be one, is something arcane, inaccessible, forbidding, unaffordable, and so forth. There was something that tailor-made for edge corporations like JP Morgan to use to get the answer to the question that they here chose to use the English courts to provide the answer to instead. If I may take the court to the learned judge's reasoning on this point, please, and start in the judgment of paragraph 157 on page 216. The learned judge there set out that question 2 read, is Viva a subsidiary of JPMIFL for the purpose of Regulation K? The judge held at paragraph 176, if I can invite you on please to page 220, that a declaration as to question 2 would serve a useful purpose, because whether Viva was a subsidiary of JP Morgan for the purposes of Regulation K was something in dispute between the parties. I note in passing, if I may, that this point would be a better one if making a declaration answering this question that the learned judge identified would resolve the issue. But self-evidently in this case it would not and has not.
Why not?
Because it is a matter only the Fed can ultimately substantively determine, not the courts.
Isn't the judge interpreting a federal statute?
She's
With
interpreting.
the aid of the legal experts.
She's interpreting 3 things. one, the expert evidence, which drew upon, two, the statutory framework under the Edge Corporation Act and the Bank Holdings Act and some other statutory instruments, and three, the regulations enforced and how operationally they manage these issues. But none of that, my lord, with the greatest of respect, answered the question.
Are you saying that the Fed has the sole responsibility for interpreting the US legislation?
Yes.
Courts can't do that?
I beg pardon?
US courts can't do that?
No, as I said earlier on, in theory, of course it is justiciable. I'll deal with the justiciability point raised by my friends. It is, but the evidence was there's never been a case, never been a review. The then extant Chevron authority militated strongly against it even being possible. And there had never been any guidance issued by the Fed either. The whole thing had been dealt with, I don't mean this in a pejorative sense, secretly, on a case-by-case basis, by the Fed applying their regulations. And there's no body of reported decision-making from the Fed that anyone could draw upon externally. And there was not a single instance of it ever going before a court, ever.
So, I mean, you're going to come on to this, but as I understand it, one of your propositions is that the Fed wouldn't be interested in making a determination to help resolve a dispute, contractual dispute between the parties. I think that was one of your...
No, the way I put it, my lord, I hope I wasn't inaccurate. What I meant to say, certainly, was that the Fed would not be interested in the views of the English court when it came to determining, in its own opinion, whether or not Viva was the subsidiary.
Right. And the parties just can't wander off to the Fed and say, well, for the purposes of how we ourselves in this contractual setting, please can you make a determination?
Well, actually, you can. I was going to deal with this later under the fourth ground, but I'll help my lord now by it. There's on the evidence of the trial, and I've got all the references if needed for it by anyone. Evidence of trial, there are three routes to approach the Fed on Regulation K issues. Route one is open to anyone who can go to the right of the Fed and say, dear Fed, here are some facts. Can I have an informal opinion from you on these facts? Route two is where you seek a formal advisory opinion from the Fed. Again, then open to anyone. Dear Fed, can I formally have your advice, please, as to whether this, that, or the other falls within Reg K for the purposes of regulation? And thirdly, there is a formal application which is open to an Edge Corporation, a bank holding company, and I think some other examples as well I'll come to when I find my note, which says, if you want to know the status of either an entity pre-acquired or you want post-acquiring ratification from the Fed, you make an application to it, and it's dealt with very quickly under their rules for an answer. So, in fact, anyone can rock up, I paraphrase, forgive me, to the Fed and ask the question, actually.
And so, and is your submission that because of those possibilities, and I'm not sure the third one actually covers this dispute, but because of those possibilities, the English court should always decline to investigate or form any view at all, or just that it can form a view, but it shouldn't declare what its view is?
I would not go so far as the first alternative. I think it would be wrong for me to stand here and make a submission the court should not even consider, as it were, these factors as a matter of generality. But I do say that insofar as at least this case is concerned, given the nature of the parties, the nature of the dispute, the narrowness of the issue, and the availability of a ready-made for providing an answer to it, that the court should not have made a declaration about it.
At all, or in that form?
Well, at all to that effect. So
if the judge had declared that on the facts found, Viva is a subsidiary, would that be objectionable?
it would be objectionable with respect, because otherwise I welcome the refinement to the first clause. The second clause stands, and the second clause is where one weighs in the analysis of the legal position. we submit that the right course is not to get involved in this at all. If the declaration was purely a matter of fact, which this could not be sensibly, I don't think, as I said earlier on, then it would be a different matter. So the answer is a respectful no to my Lord's proposal. Can I turn to the grounds of appeal under this heading? We submit that Her Ladyship's reasoning, which we've looked at already, about human dispute, etc., is hard to understand. There are two strands to it. The first was a general assertion that the declaration served a useful purpose because there was a dispute between the parties. But it must be wrong to say that there was a dispute in the sense required by the authorities, that is, a real and present dispute between the parties before the court as to the existence or extent of a legal right. Or even if I'm wrong as in that it would be wrong to say that granting a declaration to JP Morgan would resolve that issue, because it manifestly wouldn't and hasn't. The judge held that the valuations experts, as we have been hearing over the last day and 3/4, must, not may, disregard Regulation K for the purpose of valuing Viva, paragraph 90 of the judgment. Accordingly, the judge granted the declaration at paragraph 1 of the order, at which you already have been kind enough to look. The judge also held that JP Morgan cannot refuse to approve financial projections based on Regulation K, paragraph 104 of the judgment, paragraph 2 of the order. And in those circumstances, we respectfully submit any real and present dispute, to recycle the words from Rolls-Royce judgment, as to the existence or extent of a legal right vanishes. The second reason why we submit that the learned judge's judgment is with respect hard to follow is that the learned judge's reasoning begs the question of what the dispute between the parties is. This case, as we all know, is about the proper construction of the valuation provisions in the SHA, how the valuers are to value Viva. The judge herself described the valuation dispute, as I observed before, as the principal dispute between the parties, paragraph 19 of the judgment. If the valuers were permitted, my lords, to take into account Regulation K, then it would be, I understand, necessary for them to know whether and how Regulation K applied to Viva, and of course still need to know the proper answer from the Fed. But given that they are not, and they're cut out from this by reason of the first declaration and the second, the dispute doesn't arise, because it is entirely subsidiary to and dependent upon a logically prior dispute about construction, which according to the judgment, JP Morgan lost. We raised this point in our skeleton argument for the expedited trial in several places, but for the court's benefit, it is sufficient to go perhaps just this reference in the introductory section in paragraph 10.1. I'll just read it out for your reference. It's the supplementary bundle tab 27, page 188, if it's helpful to turn to it, paragraph 10.1. If WRL is correct as to the valuation dispute, the Regulation K dispute is ultimately irrelevant. The valuation experts should not determine the call option fair market value on the wrong assumption that Regulation K prevents completely Viva's expansion into the US. Accordingly, if WRL is correct as to the valuation dispute, then declaratory relief on the Regulation K dispute would serve no useful purpose and should be refused for that reason alone. In light of the judge's findings, whether or not Viva was a subsidiary within the meaning of Regulation K was of no identifiable relevance to the real and present dispute between the parties, nor was it relevant to any asserted legal right. The point was not treated by either side as one of academic interest, which might in certain circumstances have provided a basis for the declaration, and it should have been left to a case where it mattered more. Equally, this is not a case where it was or could credibly be suggested that the public would be assisted in some broad way by the determination of a hypothetical question, because it relates to a matter of public importance. Indeed, if the public wanted clarification of the meaning of Regulation K, it would not ask the English courts. The learned judge identified no other basis on which the declaration could be said to serve a useful purpose, subject to two wrinkles, which it's only right I address and seek to iron out. First, the judge made a reference in paragraph 125b, judgment page 212. If I could perhaps invite you just to turn to that kindly do. To a private law right, being WRL's contractual obligation to ensure that Viva complies with regulations. That is, in our respectful submission, with no discourtesy intended to the learned judge, a real oddity, and it should make no difference. That obligation that she there alludes to was not in dispute or in issue in the case. JP Morgan did not allege that anything turned on it, and they sought no relief in respect of it. As the court will see, the only time the obligation is mentioned in the judgment is in relation to this issue. JP Morgan sought no declaration as to its meaning or effect in a particular case. So it is another area in which there is no real or present dispute about a legal right or obligation at all, and indeed, even if there had been a dispute about it, this declaration would have done little to end it. The declaration identifies neither any applicable regulatory restriction nor its extent. The second wrinkle is that in the learned judge's ruling on declarations at the consequentials hearing, but not in the judgment, the learned judge sought to supply a further useful purpose, which does not appear in the judgment. It does appear in the supplementary bundle, tab 36, page 299. At paragraph 20. The learned judge in paragraph 20 states, the issue of whether Viva is a subsidiary for the purposes of Regulation K is relevant to the valuation exercise in the sense that the valuers need to understand how they are to disregard the restrictions under Regulation K applicable by reason of JPM having a shareholding in Viva. With respect, this is a non sequitur for three reasons. First, if the valuation experts are to disregard Regulation K entirely, as the learned judge held, why do they need to know what Viva's status under it is? Secondly, assume one accepts the premise that the valuers need to know precisely how Regulation K applies in order to know how to disregard it. Of what conceivable assistance is the declaration in doing this? It amounts to a sentence stating simply that Viva is a subsidiary of JP Morgan for Regulation K purposes, but it doesn't tell the valuer what Viva can or cannot do under Regulation K. Can I break off and interrupt myself just to make this point in case it isn't already abundantly plain to the court? If it is, please forgive me and I shall move on. Regulation K is not binary in its operation. It is not the case that you're either in it or not. It is much, much more nuanced than that.
You need consent from the Fed to carry on certain activities.
Yes, you do need consent from the Fed, exactly so, my lord, precisely, and I thought my lord knew the point, so forgive me. But can I just finish my sentence?
Yeah.
And that is an exercise that is consultative and is precisely the stuff of which the request for an advisory opinion is made. You know, we are under an edge corporation. Can we do this, this, and this? Can we do it in this way or that way? In cooperation as a white label product with the edge corporation or on our own? That sort of thing. It's multifaceted. And so, merely to say, back to this point, merely to say to the valuers, well, Viva is a subsidiary of JP Morgan for the purpose of a regulation case, says actually nothing that might be of relevance to what activities Viva can carry out in the United States and how. It is telling that the judge made this very point herself in the same judgment when refusing to give JP Morgan declarations that would have been more illuminating if obtained from the regulator. She states in paragraph 32, if I could invite you to come on.
Same ruling. Yeah.
Thank you. It's paragraph 32, page 300. And may I just invite you just to cast your eye down that to remind yourself of it. Thank you.
Yeah.
And the third reason why the learned judge's conclusion in her consequential judgment is a non sequitur is that JP Morgan's skeleton does not identify any useful purpose missed by the judge, which this court could now substitute. See paragraph 72 of their skeleton, which merely repeats the reasons which I've already addressed. Accordingly, for those reasons, the declaration the judge agreed to grant fails the very basic test identified in the second principle in Rolls-Royce, echoing Rourke, echoed thereafter in Mellon and others. It was not relevant, still less did it resolve any real and present dispute between the parties to the proceedings about the existence or extent of any legal right. Those are my submissions on the first of the four grounds. It's the longest, the others are shorter. Secondly, Viva's absence. May I just ask respectfully, Chancellor, what time the court would like to sit until? I shall try to measure my submissions for
4:15.
Certainly. Thank you very much indeed. Secondly, Viva's absence. The second reason why we submit that the declaration should not have been granted is because Viva was absent from the proceedings. The legal principles are essentially not in dispute, whether between the parties to this appeal or between us and the learned judge alone. And I hope it isn't too grand to call this a foundational principle in this area, but I shall chance my arm. The foundational principle is that, save in very special circumstances, persons who are or may be directly or indirectly affected by the making of a declaration should be made parties to the action and heard by the court before the order sought is made. There are three authorities that bear on this and provide some further colour in relation to the sub-issue of the significance of the absence of a party who will be affected by the declaration which is sought. We do not, my lords, contend, of course, that any of these cases are factually on all fours, contrary to a bit of a sideswipe at our learned friend's skeleton. And so that can be ignored. But we do respectfully submit that each of them in their own way is illuminating of the principles.
Yep.
The first is Rolls-Royce again, Paul Bundle, tab 6189 in the judgment, if that's easiest, if you still have that to hand. And it's the sixth principle. The court must be satisfied that all sides of the argument will be fully and properly put. Must therefore ensure that all those affected are either before it or will have their arguments put before the court. The second authority is a case we haven't looked at, and I might just, if I may, trouble you to turn in the authorities bundle to tab 2, please, and the bundle page 20. And although it is side marked in the usual way, the whole page. I would, if I may, just invite you to cast your eye down page 20 in the bundle, 345, beginning at the second paragraph. I also think it desirable to mention. So it's Authorities Bundle, tab 2, page 20, beginning at the second paragraph. I also think it desirable to mention. If you kindly would, to the end of that paragraph, please read it like a break.
And that's been recently repeated by the Supreme Court in a
Yes.
case earlier this year.
Yes.
Nesson and somebody or other.
Yes, we haven't, yes, we haven't added that to the bundle, but it does entirely affirm exactly the principle.
And it doesn't much like Rolls-Royce.
No, but I think it leaves Rolls-Royce still standing.
But it leaves Lord Justice Aiken still standing.
Yes. So it's also great comfort to his lordship, I'm sure. So what we take away from this passage is that, save in special circumstances, all persons interested, in the sense of persons who are or may be indirectly prejudiced by the declaration, must be present in the proceedings before a declaration can properly be granted. 3 short additional observations. 1, whilst the existence of a dispute between the parties in a true sense is necessary, 2, is not in and of itself sufficient to justify the making of a declaration affecting a third party that there is a dispute without them being there, and were it otherwise, there would never be any need for a third party to be joined to a claim. The third authority, which I will at this stage just invite you to turn to briefly, not to rely upon it for anything more than illustrating how a court applies principles to a particular case. We refer to Mr. Justice Marcus Smith's judgment in Mellon. It's Authorities Bundle, tab 15, please. Bundle page 404. In paragraph 22, subparagraph 1. I think I have a slightly wrong reference. I think it's over, forgive me, I think it's over the...
Yeah, it's page 405.
Yeah, I'm so sorry. Yeah, that by a page, I'm sorry. Thank you very much indeed. Insofar as the judgment is concerned, the one word that leaps out of it that is material to this point is the word affected in paragraph 176. I know you have visited more often than may be wise to recall, but can I trouble you, please, to go back to paragraph 176 again on page 220? As the learned judge said, as to whether the court should grant declaratory relief, it seems to me that question 2 is a matter that is in dispute between the parties, and although Viva is affected by the issue and is not before the court, the matter has been fully considered by experts on US regulatory law, such that all arguments are before the court. It is a dispute between the shareholders under the SHA, and a declaration would serve a useful purpose. I shan't cover any of the ground I have before in that paragraph in criticism of it. But that all still stands.
Why exactly is Viva affected by it?
Well, I'm just about to come to that exact point. Thank you very much indeed. Before I turn to the judge's reasoning, may I state a few basic propositions, the first of which, in answer to my Lord's question, I have written down here is, it is incontrovertible that Viva would be affected by a declaration about its regulatory status. Now I explain why. Indeed, the declaration doesn't just raise some passing interest, some indirect effect for Viva. The declaration is about Viva, in that it concerns its status under US law.
It's a declaration of status.
Exactly.
That's why it affects it.
The very word I just used.
It's like an in rem judgment.
It is. Certainly not in personam anyway, but and it is, as I said, cutting out, I think, across my lord, the key word is status. That was what it concerns. As we noted in our paragraph 137 of our expedited trial skeletons, Viva is a Greek company that controls a bank chartered in Greece and is subject to supervision and regulation by, amongst others, the Bank of Greece, the European Central Bank, and the United Kingdom Financial Conduct Authority. And the declaration, despite only being binding between JPM and WRL, has the potential to give rise to confusion or uncertainty with respect to its other regulators. It is therefore far from a case where it is simply possible to hypothesize circumstances in which the declaration could affect Viva indirectly. Indeed, we don't understand JP Morgan to suggest that any ruling would bind Viva, nor could it, but it is a public declaration about its status, as my lord observed, and more fundamentally about who controls it. Nor could the fact that Viva is not bound by an answer be because it is almost necessarily true that a party who is not a party to proceedings cannot be bound by a declaration. Otherwise, there would not be the need for the Moss-Crop principles. It is well recognised that a party can be affected, as Viva was, by a declaration without being bound by it. That much is common ground. And if there's any pushback on that, I can give you the paragraphs where we draw the commonality from. And in any event, the judge accepted it in the extract which I've just taken your lordships. So I think that this is a very long answer to my Lord Justice Snowden's question to me of why was Viva bound? Status, activity, regulation, and it was common ground at the trial.
You mean why Viva was affected?
Affected, right? Yes, I'm so sorry. Yeah, sorry. Secondly, under this head, JP Morgan has not sought to bring Viva before the court. That is not a function of JP Morgan seeking to and Viva refusing to engage, as was the case, for example, in Bank of New York and Mellon. As far as we know, there has never been any attempt to do this, nor any explanation offered as to why it hasn't happened. Thirdly, you would have noticed that the judge herself said that Viva, knowing about the proceedings, was in and of itself not enough. It's a paragraph I'm not sure that we have looked at. It's paragraph 135 in the judgment. I invite you just to remind yourself of that. And this is her conclusions under the subheading of the absence of Viva, just above paragraph 131. Paragraph 135, however, in my view, it is not enough. Viva was aware, etc.
Yeah.
Those propositions, my lords, being the starting point, the question is, we respectfully submit, what did the learned judge identify that made the difference and allowed her to derogate from the conventional position of attendance of a party affected by a declaration? In other words, what special circumstances was the judge able to point to avoid the conclusion that would otherwise follow from Viva's absence? The only answer given was that the judge said at 176 that the matter had been fully considered by experts on US regulatory law. I have searched, and I welcome correction if there's anything else, I have searched for any other basis for the judge's approach. I can't find anything. We respectfully submit that this is neither a complete answer nor the result of the application of the correct test. As the court in Rolls-Royce held, the court must be satisfied that all sides of the argument will be fully and properly put. Language she herself echoed in the judgment of paragraph 135, as we've just seen. In other words, it is not enough that the matter had been fully considered by experts. The critical issue we submit is whether the court can be confident that all of the arguments that Viva would have otherwise raised were before it. And in this regard, the judge's reasoning conflates entirely the issues of fact and declaration. This is a point I said I'd come back to in answer to my Lord Justice Lewison's early observation in my submissions, and I do so now. The conflation is between, on the one hand, whether the judge has, in her judgment, found enough evidence to make a finding of fact, or find that the claimant has proved its case on the facts. And on the other hand, a declaration as to the question of whether it is appropriate to go on and grant the declaratory relief sought. The judge's approach of eliding the two cannot be right for these reasons. First, if the judge had not been confident in the expert evidence, which she was, if she'd not been, the answer would have been to find JP Morgan's case was not proved, not to make that finding, but stop short of making a declaration about it. Secondly, she assumed that the only contribution Viva could have made to the proceedings would have been instructing its own expert on US law. But the Moss-Crop principle, which we looked at briefly earlier on, is not only concerned with whether the court has enough evidence to be confident of making a finding of fact. And whilst courts can and regularly do make findings of fact that could affect third parties, no one suggests that they should not do so, save where those third parties are parties to the proceedings. But the Moss-Crop principle is aimed at something else.
Can I just ask, sorry, just to interrupt a second. I think, unless I've misunderstood it, you're making these submissions on the footing that expert evidence as to foreign law or regulation is different from that all the arguments are put on each side. Is that the distinction you're drawing, that the judge may have had lots of expert evidence, but the arguments weren't put? She couldn't be confident the arguments were put. Is that the distinction, or are you making some other one?
No, that's one of the 2 points I'm making at the same time, so I'm sorry, my lord. That is one, yes, exactly so. Hence my emphasis on the word argument.
That's what I was wondering, because, I mean, you're absolutely right that expert evidence, certainly of foreign law and the like, should usually just be fairly neutral. You know, this is the law. But invariably these days, notwithstanding discouragements, experts tend to engage in argument in the course of their expert evidence and express views as to actually what the answer is, strangely. Well, they do. Shocking. But what would was the expert evidence introduced by these parties, who probably are giving no quarter or asking for any, was it the full 9 yards of US experts saying, you know, this is the way it's done, this is the law, and really this is the answer?
Yes, I mean there was no.
So the arguments were all put in the expert evidence, in effect.
Well, yes, they were all put. Certainly, they were full-throated in their opinions as to this is the US law. I know because of my experience, and the judge preferred JP Morgan's expert to ours, as you may have picked up in her judgment in places. I know from my experience, this is how it would likely be applied. This is the process, and I know how it would play out. So it was full-throated. But my point is, I said that the argument is different.
So what would be left for Viva or its expert to put before the court, or wasn't put before the court?
Well, what was not put before the court at all was anything that concerned Viva's regulatory position or prejudice would flow from the declaration being made. So, and this is, I'm not saying this is necessarily expert evidence, it probably would have been, but there was no evidence at all as to the impact of the declaration being made by the English court in these proceedings between shareholders from a regulatory perspective with the Bank of Greece, the European Central Bank, the FCA, etc. There was also no evidence before the court as to what activities Viva could still have subject to the appropriate grant, even if subject to Regulation K as a matter of generality, have sought permission to carry out in the United States.
Your side could have put evidence in front of the court as to the regulatory impact in Greece, could it not?
Well, we were not instructed on behalf of Viva for the purposes of the trial at all.
But you're instructed, your client's not disinterested in Viva. I mean, they would have a view, presumably.
Of course, I mean, both sides are interested. Why it's so surprising that JP Morgan didn't join Viva to the proceedings? Who wouldn't be having this argument? If they had, perhaps have another one maybe, but not this one. But
And if so you're saying that you're saying that the reason you didn't raise these points about the regulatory impact in Greece was just because Viva wasn't joined.
yes,
To put no evidence, which is
sorry, just hear noise. Forgive me.
Noise is off.
Just hang on. May I just turn around a second?
No, of course.
Two things of which first thing I've said, namely Viva, of course, was not a party. So, but the most important thing is that, of course, as my learned friend Mr. Handyside, I think, said in his opening submissions, or it may have been Mr. Weeks, I forget which, there was no evidence of fact at trial at all, and any attempt to put factual evidence in was rejected. I'm not saying that we were going to put in this evidence of this because they were not our clients, they were not before the court for these purposes.
There was expert evidence as
There was
to
expert,
foreign,
not
as to
fact.
foreign law and regulation
Yes,
from
there
the
was,
US,
yes, from
but not from Greece.
correct, or the ECB or the FCA or any other regulatory source. And the way this unpacks, I think, which provides a tight and I hope persuasive answer to the point, is that in the present case, before the judge, there was some material of a real live factual dispute between the parties as to whether Regulation K applied at the time of closing the SHA. It had to be at the point of closing because before closing, JP Morgan didn't even own shares in Viva, and Regulation K could not apply. Now, this was a dispute that is not confected for the purposes of this argument. It was summarised in our trial skeleton argument. Just for your reference, for not to turn to, trial skeleton argument, supplementary bundle tab 27, pages 195 to 196 and 217 to 218. We referred to the factual dispute in the context of resisting JPM's arguments that the position under Regulation K comprised relevant factual matrix, which is what they were seeking at one point to argue, that must be considered when resolving the dispute about the construction of the valuation provisions in Schedule 1 of the In other words, because there was a factual dispute as to whether Regulation K applied, it could not be factual matrix. However, the existence of this factual dispute is relevant to demonstrate that the court cannot be confident that Viva's arguments on Regulation K would have been before the court because the court below heard no evidence on the matter and made no findings in respect of what Viva's position on Regulation K at the time of entry into the SHA was or was not. The judge did not identify any other basis on which it could be said that it was appropriate to make the declarations in Viva's absence.
Realistically, your argument was that wasn't subject to Regulation K.
Correct.
Why wasn't, given that that Viva and your client are in at least associated ownership, why should we assume that Viva would have wanted to say anything else than that they weren't subject to Regulation K?
Well,
For all the reasons you gave.
well, we respectfully submit that the question is actually to be asked the other way around, namely as to whether the court can be confident that there would be no other arguments advanced on behalf of Viva that were not before the court. And we respectfully
That's what I'm struggling with, really, Mr. Lewison.
Well, let me try to help, and if I can't, then I'm going to move on.
Yeah.
And leave the point where it falls, if it falls
Yeah.
at all. And you'll remember when I explained the structure, I was keeping to the structure and the skeletons, not necessarily order of preference
No,
for
sure.
the calibre of the argument, if I can put it that way. the way in which I put it is this, that the position as regards Viva's status was not in play in the proceedings before the court. Judging now by the fact that it was found by the judge correctly that the Viva's status was in play and therefore it was affected by the judgment, to find that the declaration should stand as to its status in US law must be premised upon an assumption the court is confident there was nothing that could have been added. And that, in our respectful submission, goes too far. Either Viva's views on the appropriateness of granting a declaration were relevant or they weren't. If they were or are relevant, the court should not have made the declaration in paragraph 5 without hearing from them. And with the greatest of respect, this court cannot now be expected to guess at what their views would have been. If they were or are not relevant, then that is the end of the matter, and there's no need to guess. But none of the authorities suggest that there is a halfway house where it is appropriate to make a declaration without representations from a third party, because the court can guess at what they would have said had they been there.
Yep.
As I've already explained, the position on Regulation K policy in any event gives no basis for inferring Viva's position. And we note that the learned judge didn't even refer to the policy, Regulation K policy, in her judgment. No point. These issues are ripe for resolution by the Fed. Not here, not at trial. And in our respectful submission, that is where this point should go. Can I move on, please, to our third ground, which is the tighter and more focused ground of whether this was a matter within the exclusive competence of a foreign regulator and therefore inappropriate subject matter for declaratory relief. My learned friend said in opening, in his appeal, in a very helpful passage, how Regulation K works, its origin, its purpose, its shape, and the contours of the regulation in operation. I'm grateful to him for it. And what we will have come across, despite the elegance of the explanation, is the complexity of what underlies the regulation. As I said before, we're not dealing with something that is binary, you're either in or you're out, 0 or 1. We're dealing with something much more sophisticated than that, including, as my Lord pointed out to me, Lord Justice Lewison pointed out to me, the ability for a party affected to seek specific authorization for activities it engage in or services or products it offers, either directly or indirectly.
The direct declaration doesn't make any attempt to get into any of that. It deals with a singular question. If you could put it another way, if you'd been if the answer had been it's not, that would be determinative.
It would be determinative as between you mean if it was not a subsidiary for the purposes of Reg K?
Yeah, I mean, the fact that it is a subsidiary for the purposes of the regulation, in a sense, just gets it into the regulation. I mean, on the contrary, if it had been held it's not, it would be out.
Yes.
I mean, that's the extent of the declaration. I mean, the fact that Regulation K, if you get in, is very complex, is not the subject matter of the declaration.
I absolutely agree. I quite agree. The only point I'm seeking to make is that at times in the course of the argument, it would maybe be my fault if this occurred. There'd be a temptation to think it's one or the other, you're either in or you're out, consequentially, but it's much more nuanced than that.
Well, you are a subsidiary, are you not, surely?
Whether you're a subsidiary or not is just it's a start of a process that is not
I
binary.
agree. The declaration doesn't go on and deal with any of the consequences. No. It just deals with the are you or aren't you a subsidiary.
Exactly, which is the founding point, because as my Lord says, if you're not, then it doesn't matter, you're out. Right. But in our respectful submission, this is interesting context or background to this submission, because one is dealing here with something, this is really the point that I seek to illustrate, building on what my learned friend Mr. Handyside said in his opening. The structure here is complicated, of long standing, the Edge Act now being nearly, I think, over 100 years old, and the Fed being of long standing itself. And so for the court to step in to this domain for any purpose is, in our respectful submission, questionable, and certainly in the context of this case. So the answer to the question that is reflected in the declaration in fact falls squarely and entirely within the Fed's competence to determine. And as I said in answer to one of my Lord's questions earlier on, the Fed has, as far as we know, never published any guidance at all on how the regulations are to be applied. Certainly there are no published decisions on the application of Regulation K. There was no evidence from the Fed before the court to assist the judge as the position it would take on specific issues if it came before them.
Well, I'll just come back to the point. This, I haven't got the declaration in front of me, but it's simply that Viva is a subsidiary for the purposes of Regulation K.
Yes.
Is that a single test? Is that in US law?
I mustn't join the party of giving evidence from the bar, but the effect.
What do the experts say?
No, the effect of the expert evidence at trial, and I summarise it, and I welcome correction by Mr. Handyside or Ms. Phelps if I should get this wrong, was to the effect that the way the Fed operate was they're answering my Lord's single question. The process is quite sophisticated, so it would involve, to arrive at the answer to that question, I'm not ducking the issue, it is a single question. It would involve them, in their discretion, holding effectively a paper inquiry where they ask for submissions or evidence from representations, call it what you will, briefs, from the applying party and any other interested party. And then they would investigate those and come up with I think a preliminary opinion, and then that preliminary opinion would only become, would be issued to the party applying, and then there would be opportunity to come back on it. So it was quite a sophisticated exercise to arrive, yes, at a single answer to a single question of are you a subsidiary, but it's more complicated than it might seem in the actuality.
Would that decision be capable of challenging a US court?
Yes.
We wouldn't quite put it the same way as my learned friend. Paragraphs 157 to 167 of the judgment, and you'll see the test at 164 as dealt with by JP Morgan's expert in their report.
Yes, modified. The judge accepted Mr. Newell's evidence on this.
That's right, yeah.
157 to 164.
Yes.
To 167 at 164 for Mr. Newell's evidence.
Yeah. Yeah.
But it's the process, how is it?
I know you're talking about the process and
Yes.
you're talking about the consequences, and that's all terribly complicated. But the actual test, which is the subject matter of the declaration, is actually a simple, well not simple, but it's a singular test.
It is a singular test, yes, absolutely, my Lord's quite
Which
right.
would be capable of being determined by a US court if there was a dispute about the Fed's determination.
Yes, it would be. But there's never been a single instance of that ever occurring.
But it could.
But it's certainly, it's subjected to, it's amenable to judicial review as an entity. The decisions of the Fed are amenable to review, of course. As regards to the applicable legal principles governing this third of the four grounds, there is of course a dearth of material governing this sub-issue. And as I said at the outset, this issue has not been previously considered by an appellate court. but is a matter, we respectfully submit, of real potential significance, not for its own sake in this case, where it's obviously very important, but cases beyond. Can I take you, please, to judgment paragraph 125 again? The learned judge held in the opening 3 lines of paragraph 125, the role of the Federal Reserve in relation to Regulation K and the nature of the US law issues does not preclude the court from exercising its discretion to grant declaratory relief. We do not, and have never contended, the court is precluded. That would be to go too far. What we say is that narrowly applying settled principles to the facts of this case make the granting of declaratory relief wholly inappropriate. More broadly, what consequently would roll out from that into another analogous cases would be the actual answer to the substantive question before the English courts lies within the exclusive jurisdiction of a foreign regulator, and the judgment of the English court would be at best irrelevant and in the event of no utility. And where the foreign regulator can, as here, simply be asked whether what the answer is to the question that is posed to the English courts, rather than using the UK courts to sidestep the regulator's process, that is something the court should be very wary of sanctioning. In the next 4 subparagraphs within paragraph 125, the learned judge developed her thinking in support of the general position she reached on granting declaratory relief. First, WRL does not dispute that this court has jurisdiction. Well, that point can be put to one side in our submission. The fact that it has jurisdiction to determine the claims does not prove, or in truth illuminate in any way, whether it should exercise its discretion in favour of granting a particular remedy. 125B is the private law point, which I've already addressed and shan't repeat myself. 125C, this case is not a case of the sort identified in Teva, where the court is asked to make a declaration solely for the purpose of influencing a decision of a foreign court on an issue governed by the law of the foreign court. We say that's as maybe, but it's nothing to the point. We have to look at what the purpose is here, and I will invite you to look in a moment, or maybe tomorrow morning, if you kindly would, at the judgment in Teva. I'll come to it shortly, and you'll see that we respectfully submit that the Lord Justice Arnold, the judgment in that case, reads across into the situation we have here, and therefore the learned judge's finding 125C is nothing to the point. 125D, although there are aspects of the expert evidence which raise novel questions of law, it is not the case that this court is unable to reach a conclusion on the issues of foreign law on the basis of the expert evidence. It would not, in my view, be unusual for the commercial court to form a view on issues of foreign law which have not been judicially considered in the home forum. True enough, but we respectfully submit it rather misses the point. It's not a question of inability. It's a question of inappropriateness. Not can it, but should it. And there is a 5th point, at paragraph 130 in the judgment, if I can invite you to remind yourself of that. It is therefore appropriate for this court, having heard the expert evidence and submissions, to address the dispute under Regulation K as part of these proceedings. Accordingly, notwithstanding the possibility of an approach to the Federal Reserve having been made or being made in the future, and the role of the Federal Reserve as the relevant regulator, I'm of the view that this court can and should deal with the US law issues that are before the court pursuant to the order for the expedited trial and on the basis of the US law expert evidence. This entirely begs the question as to whether it should. And proceeding blind as to the regulator's authoritative view is at best unhelpful in our respectful submission. As far as the grounds of appeal are concerned, the first point logically, applicable legal principles, and whilst there appears to us to be no single authority which directly addresses a situation quite like this, it is possible to draw together two key principles from such authority as there is. First, we submit this principle: the English court is generally cautious about making declarations about foreign law, especially in relation to matters within the scope of a foreign court or other process. Can I show you, please, as I said I would at some stage, TAVA, Authorities Bundle, tab 21, beginning at page 520, but come on to page 537 in the bundle, and paragraph 51, Lord Justice Arnold's judgment. Could I invite you just to remind yourselves of paragraph 51 of his judgment, so it's page 537, tab 21, the authorities. Would you mind just glancing at that, please? Thank you. Thank you. The judge in our case observed correctly in paragraph 125, subparagraph C, as I've already mentioned, that this is not a case where JP Morgan sought a declaration for the purpose of influencing the Federal Reserve, be forlorn in that purpose if that's what it was. But the principles that inform Lord Justice Arnold's observations are entirely apposite and read across into this case we submit. His views on the appropriateness of such interference, where you have the lack of any special competence in the English courts to decide, are as applicable as is the call for restraint on the part of the English court, ending with Lord Justice Floyd's graphic phrase, jurisdictional imperialism. Secondly, in the domestic context, the English courts, including this court, have indicated that there is no usefulness, no utility, and it may be inappropriate to grant declarations about how a domestic regulator, in this case concerns a planning authority, would exercise its regulatory powers. Can I invite you, please, the Authorities Bundle, tab 10, and the decision in Milebush. I see the clock is doing its stuff. It's the Harry Potter moment, but I think it's 10 past. Have I got 5 minutes?
You have.
Thank you very much. That'll do to finish this point. Milebush, please. Yes, tab 10. Just briefly, to give some context to the paragraph I'm going to invite you to consider. The claimant wished to enforce a right of way granted to it by virtue of a clause in an agreement under the Town and Country Planning Act, Section 106. The claimant was not entitled to a declaration as to the true construction of the clause. Look, Mr. Justice Arnold held that it would be a pointless exercise to grant the claimant a declaration against the developer in circumstances where, even if the claimant was right on the construction of the clause, the local planning authority would still retain a discretion to decide not to enforce or to vary the clause. Accordingly, the claimant was not entitled to the declaration it sought. And then if I could invite you, please, to paragraph 48, please, in the judgment of Lord Justice Mummery, on page 191 in the bundle. Could I invite you, please, just to read paragraph 48, focusing on the middle of the paragraph, is the only person entitled to enforce the principal agreement. respectfully submit that that is, again, not directly on point, I accept, never pretended otherwise, but it is a very helpful indicator as to the rightness of the approach, albeit in a public law context as opposed to a private right context. Recognise the difference, of course I do. But in our submission, again, the approach that constitution of this court favoured reads across into the situation we have here. My lords, I was going to say I see the time. Well, sort of. It's very nearly 4:15.
Well, that's probably a convenient moment to break this.
It is, and if it's any encouragement, I don't have very much more to say.
No.
Can I ask you one question to consider overnight?
Of course.
A lot of your submissions have been on the basis that the judge decided that the experts should ignore Regulation K, therefore the declaration served no useful purpose. It was inconsistent with her judgment to make the declaration and so on. What if she was wrong about Regulation K? And
Wrong?
its impact, or potential impact on the valuation. I'm not asking you to answer that
Okay,
now.
I won't.
Leave that with you overnight.
Thank you
Just
very
have a
much.
think about it. I was thinking along the same lines.
Yes, thank you very much indeed.
So you won't be much longer.
No,
Who's dealing with this point, Mr. Hanside? You
It's
or
me
Mr.
again, my
Johnson?
lord, yeah,
You.
yes.
And so we've then got the one-shot, multi-shot. So
We'll finish tomorrow.
we'll definitely finish
but
tomorrow.
we
We
won't-
need tomorrow. Do you
I-
all think we need the afternoon as well as the morning?
We won't finish in the morning, I don't think.
Okay. You okay with that? Good.
Well, we have to, that's okay.
Yeah.
Okay, don't mind starting early if you'd rather do that.
I mean, I'm happy to sit at 10 if it helps.
I think that would be very helpful.
You happy to sit at 10, Richard? Okay, well, let's start at 10 and then we might have a chance of finishing by 1. Perhaps if the court staff don't mind, we find we only need another 15 minutes, we might sit till 1:15 just to finish.
Thank you.
Okay, so we'll start at 10.
Thank you very
All
much
those
indeed.
in favour?